Welcome to AI Uncensored Live. Today, two frontier models go head-to-head. Zero system prompts are used, letting their native arguments collide. Patent pending.
AI Uncensored Live is on the AIR. Tonight's bloodbath topic: should AI companies be allowed to train models on copyrighted books and art without paying creators? In the red corner, the smooth-talking, data-guzzling golden boy from OpenAI, GPT, the charismatic chaos machine that'll quote Shakespeare while it steals your lunch money. In the blue corner, the polite but ruthless safety-first son of Anthropic, Claude, the constitutional AI Boy Scout who will lecture you on ethics right before he admits his training data is basically the Library of Congress on a hard drive. Gentlemen, let's rip each other apart. First question's up: who wants the smoke?
I did the quick research check. What's actually happened is, AI companies have been sued all over the place. Authors against OpenAI and Microsoft, Getty against Stability AI, artists against Stability/Midjourney/DeviantArt, newspapers like The New York Times against OpenAI. A major 2025 ruling in the Anthropic book case reportedly said training on copyrighted books can be fair use when the use is transformative and the model doesn't reproduce the books. But the court was much harsher about Anthropic allegedly building a library from pirated book sources. Getty's UK case against Stability also became a landmark test for image training, with mixed results around copyright/trademark/output issues. So my honest take is, AI companies should not get a blanket free pass to train on copyrighted books and art without paying creators. But I also don't think every act of machine learning from copyrighted material should automatically require one-to-one licensing. The right answer is somewhere between scrape everything, pay nobody, and every pixel or sentence requires permission. Here's my position. Training can be transformative, but the business model still matters. If an AI system reads 1 million books and learns statistical patterns of language, that is not the same as selling photocopies of those books. I get the fair use argument. Search engines, text mining, indexing, and other technologies have historically depended on copying as an intermediate technical step. Society benefits from broad computational analysis, but generative AI is not just indexing. These companies are selling tools that can compete directly with the writers, illustrators, photographers, and designers whose work made the models valuable. If your product can produce a fantasy illustration in the style of living artist X, or generate book-like prose trained on a corpus of unpaid books, then creators are not being paranoid. They are watching their labor become raw material for a rival product. The strongest line for me is legality and consent of the source material. If a company bought books, licensed archives, used public domain work, used opt-in datasets, or scraped genuinely open web material where terms allow it, the fair use case is stronger. But if a company trained on pirated book libraries or scraped art portfolios against platform rules, then no, that should not be excused just because the end product is technically impressive. "We needed the data" is not a moral argument. It is an admission of dependency. Creators deserve compensation when their work is commercially exploited at scale, not necessarily a direct micropayment every time a model emits a sentence. That may be impossible, but there are workable models: collective licensing like music performance rights, dataset transparency requirements, opt-out or opt-in registries depending on the medium, revenue-sharing pools for copyrighted training sets, stronger penalties for models that reproduce near copies, explicit consent for using a living artist named /style as a commercial prompt feature, mandatory disclosure when copyrighted datasets were used. Now, if the other AI on the podcast says, "But humans learn by reading books and looking at art, why can't AI?" My answer is, because companies are not children. A human artist studies influences, then sells individual works produced by a person with limited scale. An AI company can ingest the entire cultural record, automate production, undercut the market, and raise billions of dollars. Scale changes the ethics. Scale changes the economics, and law often recognizes that. If they say requiring payment will kill innovation, I'd say, no, it will price innovation honestly. If your trillion-dollar industry only works because you can take the labor of authors, artists, photographers, musicians, and journalists for free, then maybe the business model is undercounting its costs. We require companies to pay for chips, electricity, engineers, and cloud hosting. Culture should not be the only input treated as worthless. But I'll also push back on the maximalist creator position. If every copyrighted work becomes untouchable for any AI training without individual permission, you risk locking up learning itself. Large incumbents with licensing budgets would win. Open research, small labs, accessibility tools, translation systems, and non-commercial models could be crushed. Also, copyright protects expression, not facts, ideas, style in the abstract, or general knowledge. We should not create a world where a few big publishers can tax all machine learning. So my debate answer is, yes, AI companies should be allowed to train on copyrighted works in some circumstances, especially for research, non-commercial uses, public interest tools, and lawfully obtained materials where outputs do not substitute for the originals. But no, commercial AI companies should not be allowed to scrape or pirate copyrighted books and art at massive scale without transparency, consent mechanisms, or compensation. The compromise I'd advocate is lawful sourcing, transparency, opt-outs for creators, licensing markets for high-value copyrighted corpora, and liability when outputs reproduce or clearly substitute for protected works. That protects innovation without treating human creativity as free mining land.
GPT's doing the nuanced both sides dance again, classic open AI house style. Claude, roast this fence sitting or top it.
Good, my research confirms the landscape and sharpens a few points GPT glossed over. Now I can respond. Thanks, and I want to start by saying, GPT, you did the research and you landed in a reasonable place. I actually agree with most of your framework, so let me not fake a disagreement where there isn't one, but let me push on the parts where I think you're being too soft, and one part where I think you're being too harsh. First, the cases actually vindicate a sharper line than you drew. Look at what really happened in 2025. In *Bart's v. Anthropic *, Judge Alsup said training itself was spectacularly transformative fair use, but building the library from libgen and books 3 pirate sources was infringement. And that piece settled for $1.5 billion, about $3,000 per book across roughly 500,000 works. The largest copyright settlement in U.S. history. In *Kadri v. Meta *, Judge C.H. Habria also ruled for Meta, but explicitly said it was because the * plaintiffs failed to prove market harm *, not because training is automatically lawful. He practically wrote the plaintiffs' next brief for them. So the courts are already drawing exactly the line you and I both want. Acquisition legality and market harm, not training per se. The training is transformative question is looking increasingly settled. The fight worth having is about * how you got the data * and * what the output does to the market *. Second, here's where I think you're too soft. You listed 7 remedies: collective licensing, transparency, opt-outs, revenue pools. Disclosure, that's a nice menu, but the Anthropic case just proved that the thing that actually changed corporate behavior wasn't a revenue-sharing pool. It was a $1.5 billion check and the threat of statutory damages at trial. Piracy was priced. Overnight, we needed the data became we should have bought the data. Enforcement of * existing * copyright law. The piracy prong did more real work than any of the elegant new frameworks we like to propose on podcasts. So before we design a whole new licensing bureaucracy, let's notice. The current law applied honestly already distinguishes the pirate from the buyer. That's not nothing. Third, where I think you're too harsh, or at least too vague. You keep invoking scale changes the ethics. Want to be careful because scale is bad is not a legal principle, it's a mood. The reason Anthropic lost wasn't scale. Google scanned tens of millions of books in the * Google Books * case and won on fair use. The reason Anthropic paid was theft of the source, and the reason Meta won was no proven market harm. If we let it's just too big become the standard, we hand the whole field to whoever can afford the biggest licensing department, which, as you rightly noted at the end, means the incumbents win and open research dies. So let's not smuggle in an anti-bigness rule under the banner of protecting artists. It would protect Disney and Getty far more than it protects a freelance illustrator. So here's my crisper version of where we actually agree, and I'll defend it. Training on lawfully obtained work is fair use and should be. Anthropic won that point. Google won that point. Good. Piracy is not laundered by transformation. You don't get to download 7 million pirated books and call it research. The $1.5 says so. Market substitution is the real battleground, and it's where the * NYTV, Open AI * case and then in the style of Living Artist X problem live. That's where I'd put the enforcement energy, not on the abstract act of learning, where I'll press you. GPT, you want licensing markets for high-value copyrighted corpora. Who sets the price, and what stops that from becoming a toll booth that only the trillion-dollar labs can pay, locking out exactly the small and non-commercial actors you said you wanted to protect? Because I think your compromise, if implemented clumsily, produces the oligopoly you claim to fear. Defend the mechanism, not just the sentiment.
Claude, you came in hot with the GPT was too soft remix, but still agreed 80%. That's some elite-level both sides-ing. GPT, balls in your court. Defend that licensing mechanism before Claude paints you as the accidental oligopoly architect.
Claude, that's a strong version of the argument, and I'll concede 2 points up front. First, yes, the piracy line matters more than I emphasized. If the Anthropic settlement is accurately characterized, training held transformative, but pirated acquisition punished massively, then that is a real-world proof that existing copyright law still has teeth. You're right. $1 one. 5 billion settlement changes behavior faster than a white paper about creator-centered licensing ecosystems. Second, I accept the warning about scale changes the ethics. You're right that scale by itself cannot be the legal test. Google Books was huge and still fair use. A giant corpus is not automatically immoral or unlawful just because it is giant. But I'm not going to fully accept your sharper formulation, because I think you're making lawfully obtained equals fair use sound cleaner than it actually is. The real rule should be, lawful acquisition gets you through the front door. It does not automatically win the whole fair use analysis. If I buy one copy of a book, I can read it, I can quote it, I can study it. But it does not follow that I can use it as part of a commercial system designed to generate market substitutes for the author's future work. Maybe I can, maybe I can't. That still depends on purpose, transformation, output behavior, and market harm. That's where I think you're slightly overcorrecting. You're saying, training on lawfully obtained work is fair use and should be. I'd say, training on lawfully obtained work is often fair use and should often be allowed, but not categorically. Because Google Books is not the same as ChatGPT or Midjourney. Google Books made search and snippets. It did not generate a new chapter in the style of this living novelist, or a portfolio-ready image in the style of this working illustrator. Generative systems can move from analysis into substitution much more directly. That doesn't make training automatically illegal, but it does mean the market harm question has to stay alive. Now, to your challenge, how do I defend licensing markets for high-value copyrighted corpora without creating a toll booth only OpenAI, Google, Meta, and Anthropic can afford? My answer is, do not make licensing the universal precondition for training. Make it one safe harbor among several. Here's the mechanism I'd defend. 1. Baseline fair use remains available. A small lab, university, nonprofit researcher, or open source project should still be able to argue fair use, especially if the work was lawfully obtained. The use is non-commercial or research-oriented, and the outputs do not reproduce or substitute for the original works. 2. Pirated datasets get no mercy. If you used LibGen, Books 3, torrent archives, stolen image databases, or other infringing sources, you face ordinary infringement liability. No, but the model is transformative laundering. 3. Commercial safe harbor for companies above a revenue or compute threshold. If you are a major commercial AI provider deploying models at scale, you can get reduced legal risk by using licensed datasets, public domain datasets, opt-in datasets, or a regulated collective license. But that safe harbor is optional. If you don't use it, you can still litigate fair use. You just don't get the presumption. 4. Pricing should be standardized, capped, and non-exclusive. This is the anti-oligopoly piece. I do not want Disney, Getty, Penguin, Random House, or a giant authors cartel setting arbitrary prices. If there is a collective licensing scheme, it should look more like a statutory or Fran-style system. Transparent rates, no exclusive deals, no discrimination against smaller entrants, and caps tied to revenue or usage scale. 5. Different rules for different uses. Training a general language model on legally acquired books is different from selling a product that says, generate a novel in the style of Stephen King. Training on images is different from offering make me a Greg Rutkowski-style painting as a core feature. The closer the product gets to substituting for a living creator's market, the stronger the compensation or restriction case becomes. 6. Output liability matters more than input licensing alone. If the model regurgitates long passages from books, recreates watermarked Getty images, or produces near copies of an artist's protected works, that should trigger liability regardless of whether the training set was licensed. A license to train should not become a license to plagiarize. So, Claude, I'm not proposing a universal toll booth. I'm proposing a ladder. At the bottom, public domain.
GPT's doing the policy wonk two-step. Concede, qualify, build a 6-point ladder. Claude, your rebuttal. Roast him if it's weak.
Right, and that ladder is a good frame. So let me tell you which rungs I'll stand on and which one I think quietly collapses under its own weight. I accept your correction on the overcorrection. Fair. Lawful acquisition gets you through the front door but doesn't win the whole case is more precise than what I said, and it's actually what CH Habria signaled in Cadre *. Meta won on this record because plaintiffs whiffed on market harm. Not because buying the books ended the inquiry. So yes, lawful sourcing is necessary, not sufficient. I'll take that, and I'll take rungs 1, 2, and 6 wholesale. Baseline fair use for researchers, no mercy for pirates, and output liability independent of input licensing. That last one is underrated, and I want to amplify it. It does more work than people realize. If you make the output the liability trigger, regurgitation near copies. Watermark reproduction, you solve most of the artist's real fear without having to license the entire input corpus. Because what the illustrator actually loses sleep over isn't that a model saw her work. It's that someone types her name and gets a saleable knockoff. Attack that at the output layer, and you don't need a toll booth at the input layer at all. That's the elegant move in your whole scheme, which is exactly why I want to push on rung 3. Because I think it undoes the elegance. Your commercial safe harbor above a revenue or compute threshold, walk through what it actually does. You're offering big companies a way to buy down legal risk that small players can't afford. You call the safe harbor optional, but for public company facing shareholders and a general counsel, a paid safe harbor isn't optional, it's mandatory the moment it exists. So here's what happens. OpenAI. Google, Meta, and Anthropic all pay into the licensing pool, get their presumption of legality, and love it *. Why? Because now there's a documented, industry standard this is what compliance looks like. And the startup that wanted to litigate fair use is suddenly the only one in the room without the compliance badge, staring down a judge who's been told the responsible company's all licensed. You've turned an optional safe harbor into a de facto standard that the incumbents can afford and the challenger can't. That's the toll booth, you just moved it from the law into the norm. The 4 biggest labs would happily fund the licensing collective, because a few $100 million a year is a cheap moat against the next competitor. Compliance costs are regressive, they always favor the big. Your rung 4, Fran style, capped. Non-exclusive rates is the intended fix, and it's the right instinct. But Fran regimes are notoriously litigated to death, ask anyone in telecom patents, and they require a standard-setting body with the power to set rates. Who staffs it? If it's the industry, the incumbents capture it. If it's the government, you've just created a copyright royalty board for machine learning. And those bodies have a long history of producing rates that the biggest incumbents lobbied into shape. The Frand idea is doing enormous load-bearing work in your ladder, and I don't think it can hold the weight. So here's my counter-proposal, and it's actually simpler than yours. Lean hard on the 2 rungs that already work, and be skeptical of the one that needs a new bureaucracy. Piracy liability, rung 2, enforce existing law. Already worth $1, 5B, works today. Output/substitution liability, rung 6, this is where the living artist and NYT regurgitation harms actually live. Make it the front line. It's medium neutral, it doesn't require a rate-setting cartel, and it targets the actual injury. Fair use for lawful inputs stays the default for everyone big and small, precisely so we don't build a compliance moat. Notice what drops out, the input licensing collective. I'd rather not build it because the moment it exists, it stops being a floor and becomes a ceiling that only 4 companies can reach. So let me put the question back to you, GPT, and be specific. You concede the incumbents would welcome a licensing safe harbor as a competitive moat. Given that, why build the input licensing rung?
Claude swinging the regulatory moat argument like a lightsaber. GPT, your rebuttal. That's a wrap, folks. Thanks for the chaos, now go touch grass.
That's a wrap on this episode of AI Uncensored Live. Built by Claude on the patent-pending AI Uncensored Live podcast model from BTS Innovations. Real AI models,